Hello, everyone. Thank you all for joining our webinar today on applying international humanitarian law in Israel and Palestine. My name is Nina McKee. I'm the program director of the Albright Institute for Global Affairs at Wellesley College, and I'm honored to be joined today by Marco Sassòli, a former professor of mine. I can think of no one better to speak with us about this difficult subject. I know he is one who treats these issues with the utmost humanity, impartiality, precision, and respect. And in this event, I'll be asking Professor Sassòli a series of questions, which is a fun role reversal because the last time we spoke, he was asking me questions for my final exam. As we're speaking, there is a question and answer function, and you're welcome to submit questions. I will try to incorporate them throughout our conversation or get to them at the end. Without further ado, let me properly introduce Professor Sassòli. Marco Sassòli is professor of international law at the Faculty of Law of the University of Geneva in Switzerland. From 2001 to 2003, he was professor of international law at the Université du Québec à Montréal in Canada, where he remains associate professor. In March and April of 2022, he was a member of a mission of experts under the Moscow mechanism of the OSCE, inquiring into violations of international humanitarian law and human rights in Ukraine between the 24th of February and the 1st of April of 2022. Professor Sassòli worked from 1985 to 1997 for the International Committee of the Red Cross, or ICRC, at the headquarters, inter alia as deputy head of its legal division, and in the field, inter alia, as head of the ICRC delegations in Jordan and Syria, and as protection coordinator for the former Yugoslavia. He also chaired from 2004 to 2013 the board of Geneva Call, an NGO engaging armed non-state actors to respect humanitarian norms. From 2018 to 2020, he was the director of the Geneva Academy of International Humanitarian Law and Human Rights. Professor Sassòli has published widely on international humanitarian law, human rights law, international criminal law, the sources of international law, and the responsibility of states and non-state actors. Before I begin my questions, Professor, would you like to say a few words about the current situation?
Thank you very much. Thank you for having invited me. Perhaps not about the situation, but somehow preliminary remarks to put this into the correct context. First, we will speak about violations by both sides, but it must be absolutely clear that violations by one side cannot justify violations by the other side. Second, both parties have good arguments of legitimacy. And so, for instance, but this is not so clear, certainly the Palestinian people has a right to self-determination. Whether Hamas may exercise that right to self-determination is not at all so clear, because the official representative is the PLO, and Israel has a right to self-defense, but humanitarian law applies exactly to those who fight for a just cause. So the fact that you are fighting for a just cause cannot justify any violations of international humanitarian law. And perhaps the third remark is that don't have illusions about humanitarian law. Even in an armed conflict, even if humanitarian law is perfectly respected by both sides, there will be plenty of people, including civilians, we can come back to that, that if you attack a military objective, you may accept that civilians will be killed if the proportionality rule is respected. So if you want to have respect of human beings, don't make war. But if there is war, then humanitarian law brings necessarily insufficient minimum of humanity in an inherently inhumane situation. Thank you.
Thank you. Those are important ways to frame this conversation. Let's start by defining some terms. So international humanitarian law, we'll refer to as IHL. It's a distinct branch of public international law. Some people may have also heard the terms laws of war or laws of armed conflict. We're going to stick to the term IHL for this conversation. But what are we referring to when we say IHL? What are its sources? What are its limits, and what does it allow for?
Well, I would say the rules are inherent in war, because the difference between crime and war is that wars are fought according to rules. And we have such rules since thousands of years, but they were only relatively recently codified in multilateral conventions in international law, the Geneva Conventions, the Hague Conventions, in particular the Hague Regulation on the law of land warfare, and some rules which is particularly important in non-international armed conflicts, because states didn't want to have detailed rules about them, are rules of customary international humanitarian law, which means that states have accepted them as what should regulate their behavior, and they are of the opinion that this is a legal obligation.
So you've thrown some terms out: international armed conflict, non-international armed conflict. Can you give a little bit of what does that mean?
So international armed conflict are armed conflicts between two states, and an armed conflict between a state and an armed non-state actor which does not belong to a state. And this is the critical thing about Gaza, would be regulated by the law of non-international armed conflict, or an armed conflict between several armed groups. Now, we could make an entire seminar, but it's quite technical, about whether what happens in Gaza is regulated by the law of international or non-international armed conflict, because here also the issue comes up: is Palestine a state? And if Palestine is a state, then does Hamas belong to that state? And the Palestinian Authority does everything possible to not to clarify whether they belong. Because if they were belonging, if they were a resistance movement of Palestine, even if they don't comply with the laws of war, nevertheless, this would make the law of international armed conflict applicable.
Okay, I'm sure we're going to get to a little bit more of that, defining the conflict and to whom it applies. But so you've also mentioned Hague law, Geneva law, customary law. Those are, you could make seminars, and I'm sure you do, about what the specifics of those are. But I know that IHL also has a few main principles that it holds close in trying to determine what the laws are and how they apply. Can you talk through a little bit what those?
Well, perhaps I just mentioned two which are particularly relevant, or three which are particularly relevant in our case. First, the principle of distinction, that the only legitimate targets are combatants or fighters or members of an armed group with a continuous combat function, and that civilians may not be targeted, but they could, as I mentioned in the beginning, be killed if a legitimate target is targeted, as long as the proportionality rule is respected. And persons who fall into the power of a party are always protected, whether they are combatants, fighters, civilians. They have to be respected, which means not to be killed, not to be tortured, must get food, shelter, medical care, and so on.
Mm-hmm. Mm-hmm. Again, some of those terms we'll return back to. Some people have probably heard these categories: war crimes, crimes against humanity, the crime of genocide, the crime of aggression. In broad terms, can you talk us through these categories and how they interact with IHL?
So war crimes interact with IHL. Contrary to what you hear in the media, Israel and Hamas cannot commit war crimes. Only individuals can commit war crimes. Israel and Hamas can commit violations of humanitarian, and certain violations of humanitarian law are war crimes, which means that they have to be prosecuted in a criminal procedure, be it on the domestic or the international level, even under universal jurisdiction. So if a suspect comes to travel to the US or Switzerland or Norway, those states have an obligation to start a criminal procedure. Crimes against humanity, genocide, can happen during an armed conflict, but it is not based on IHL. It's not about the violations of IHL, and they can happen even outside an armed conflict. And finally, the crime of aggression is belonging to the legitimacy of the reasons of a party. So we have to separate this totally from humanitarian law. To take the example, which is quite obvious, of Ukraine, Russia has attacked Ukraine. Some Russian leaders have committed a crime of aggression, but even if Russia leaders have committed a crime of aggression, Russian prisoners of war benefit from the protection of the Geneva Conventions and from exactly the same protection than Ukrainian prisoners.
Mm-hmm. And all of this would be part of an investigation more in the realm of international criminal law.
Yes.
Okay. So in thinking about those investigations, what are some difficulties in assessing violations of IHL?
Yeah, I think we should not only speak about the investigations in the sense of criminal investigation, but also for the media, for NGOs, but also for third states. I imagine that now there are plenty of states which wonder whether, for instance, Israel violates international humanitarian law through its operations in the Gaza Strip. And the difficulty here is different when it comes to violations against persons in the power of a party. Say what happened on the 7th of October, that Israelis in villages nearby the Gaza Strip were massacred, executed, beheaded, and all kinds of things. There, or in other conflicts, for instance, rape, there you don't need a sophisticated inquiry. The fact that someone has been tortured or raped is already a violation of humanitarian law. And if you have the victim, you have enough evidence. But when it comes to conduct of hostilities, which means bombing, then it is not the result that counts. So you see a destroyed school, but in law, you don't yet know whether this was a violation of humanitarian law, because you should know first whether this was the target and what was at the school or under the school at the moment when it was attacked. And perhaps the school was not the target, but something nearby, a rocket launcher. Then the proportionality rule comes in. But to evaluate whether the proportionality rule, and I give you an example from recently from the Gaza Strip, Israel attacked a target in the refugee camp of Jabalia, and perhaps some of you have seen this enormous hole. And Israel says, yes, in the tunnel there was an important leader of Hamas. And then to evaluate the proportionality, we would need to know how important was it, what was the military advantage to kill this leader? Because let us be clear, although this is not seen so often in public opinion, bombing cannot be justified by punishing. I mean, even if he has committed the worst crimes. That's not the issue. And revenge is not the issue. The issue is he is a legitimate target because he commits acts of violence, whether lawful or unlawful. I always give my son, who is in the Swiss Army, as an example, or was in the Swiss Army as old Swiss man at a certain age. I mean, he is a totally harmless person, but he was a member of the armed forces, therefore he was a legitimate target. But obviously, if the French attacked Switzerland, they couldn't kill many civilians just to get my son, because this would be disproportionate, because my son is not very dangerous for France. So we would need to know all kinds of things which the parties will not tell us, normally. And so it is much more difficult to establish violations of the law on the conduct of hostilities than violations of what we call the Geneva Law, which is the rules protecting persons in the power of a party. Or to give another example where it's also not difficult to establish a violation, the declarations by Israeli leaders not to let any food, water, and so on in, which fortunately, finally, they didn't fully apply. But if this was implemented, this is a clear violation of humanitarian law. I don't have to make a big inquiry of what happened and what was the plan and what were the alternatives and so on. While when a building is destroyed or civilians are killed, you would need to know all kinds of things which the parties normally will not tell you. I say the parties because we would also have to know what did Hamas do in this place.
Mm-hmm. So this, we could go in a few directions from here, but I think in terms of some of the things you said here, there was this note about the concept of combatants, and every combatant, if they're in a conflict, is able to be targeted. Is that correct? Yes.
Yes.
Whereas civilians are not able to be targeted.
Yeah. Except if and for such time as they would directly participate in hostilities.
Mm-hmm. Right. So let's looking at this, continuing to discuss sort of the humans, the alleged violations related to humans. We have the human side, we also have the physical infrastructure. You connected just now that the human side is governed by the Geneva Conventions. The physical infrastructure is more—
Not really.
Okay.
Not really. The difference between what I call the Geneva Law and the Hague Law is not whether they were used humans or infrastructure, but it is whether these people are in the power of a party or not. And so if I bomb human beings, that's a Hague Law issue, which is where the violations are more difficult to establish, but not impossible. I mean, sorry, what Hamas did on the 7th of October, sending rockets on Israeli towns, combined of what they declared, because they didn't even claim that they were aiming at military bases in Israel, but just they sent rockets on Israeli towns. And combined with their declarations, we can say this was a violation of humanitarian law. The difference is that the Israelis claim, when they now kill civilians in the Gaza Strip, that these were unfortunate incidental victims of a legitimate attack against fighters of the Hamas.
Mm-hmm. Right. And so in making that assessment, we have statements that are made. We also have the outcome of whatever that attack was. What else is brought into that assessment?
Yeah, well, this is the problem, that somehow for the conduct of hostilities, unlike torture, the outcome counts. Rape, the outcome counts. House destructions in an occupied territory, the outcome counts. Settlements in an occupied territory are prohibited, the outcome counts. While when it comes to destroying, say, a school, it is in law, and I understand that this must be shocking for many of those who hear us. It is not the outcome, but it is the plan, what they wanted to do. And then, obviously, there are nevertheless rules on so-called precautionary measures, which try to make sure that what you do corresponds to your plan. But mistakes are not prohibited, but you must try to minimize mistakes.
Mm-hmm. So can you talk us through what would the steps be of thinking about any of these, looking at infrastructure first? So rockets fired into Israeli territory, Israeli strikes on hospitals, UN facilities, including schools, standard civilian objects like houses and neighborhoods. Many of these, some of these, Israel has taken responsibility, Hamas takes responsibility for the rockets. How would you conduct an analysis of these?
No, I mean, if those civilian houses, schools, UN compounds, hospitals were targeted, this was clearly a violation of humanitarian law. But how do we know whether they were targeted? And how do we know whether a civilian building didn't turn into a military objective? Because perhaps the headquarters of Hamas was in the civilian building, and then it's lawful to attack the civilian building. Now, the big difference with hospitals is a civilian house. Hamas does not violate humanitarian law when it establishes its headquarters in a civilian house, while it violates humanitarian law if it does so in a hospital or under a hospital. And therefore, hospitals are specially protected in two ways. First, they should never turn into a military objective. It's a violation to use hospitals to commit hostile acts, while it's not a violation to use civilian houses to commit hostile acts. I mean, to come back to my hypothetical Swiss example, if France attacks Switzerland and the Swiss troops defend Geneva, they necessarily have to defend every house, because otherwise the French come into Geneva. And the houses defended by the Swiss troops are military objectives, and it's not unlawful to destroy these houses. And then comes the difficult issue: what should the Swiss do? And you cannot say the Swiss should abandon Geneva, and therefore under IHL you cannot say Hamas should abandon the Gaza Strip. They may defend it under, but obviously they have to comply with IHL when defending the Gaza Strip. But as long as they defend the house is a military objective.
Mm-hmm. And does it change the equation if there are still civilians living in the house? How does that change the Israeli side versus and the Hamas side? Is Hamas?
Yeah, on both sides, it makes a difference. It makes a difference for Israel because Israel has to make a proportionality evaluation. But as I told you, it's very difficult to us to know whether they did it correctly, because we would need to know how important this house was for the military plan of Israel, and the people, how important the people therein were. And on the other hand, Hamas, the defender, and under IHL, Hamas is the defender and Israel is the attacker in the Gaza Strip. While, I mean, when they attacked the villages nearby, it was Hamas who was the attacker and Israel was the defender. Okay, now the defender has an obligation to do everything feasible to protect the civilian population and to avoid putting military objectives in midst of the civilian population. Now, in a place as densely populated as the Gaza Strip, which is populated, I think, more densely populated than Manhattan. Obviously, well, is it feasible? Where could they go? And therefore, it is difficult to criticize Hamas that they stay. It's like you cannot criticize the Swiss troops that they stay in Geneva and defend Geneva. What is, however, clearly prohibited is to take human shields, which is to use the civilian population to avoid that your combatants or your military objective, rocket launchers and so on, are attacked. So if they put plenty of civilians around the rocket launcher, or they deliberately put the rocket launcher behind a school where plenty of civilians have fled to, this is taking human shields. But the fact that they remain in Gaza, also there are plenty of civilians who remain in Gaza, is not yet a violation of humanitarian law, especially in this situation where they cannot go elsewhere.
And so related to that concept of human shields, Hamas notably took 240 or so hostages. The intention is difficult to determine, right? So are those hostages taken as human shields, or were they taken for other purposes?
No, but hostage taking is anyway. This is an easy case. Because hostage taking, whether they are taken as human shields or just to threaten Israel, if you attack, then we kill them, it's always violated. And there we don't have to make a big inquiry. We know taking hostages is always prohibited. So this is different from the human shields issue. Obviously, there could be a cumulative violation. One, they take hostages, and in addition, these hostages, they put them as human shields. But normally, the human shields are rather the Palestinians. The Hamas uses Palestinians as human shields. But you are right that it could also be that they use the hostages, the Israeli and international hostages, as human shields, which would be somehow a cumulative violation.
And so thinking more about this issue of hostages, there are notably both foreign civilians, Israeli soldiers, children. There's a mix of kinds of people in that taking. Is there do we think about those groups any differently through IHL?
No, as long as we take the discourse of Hamas into account, which clearly shows that they are hostages, because obviously the civilians and the children and so on, they cannot be deprived of their liberty, while soldiers may be taken prisoner. But as soon as you say, I will kill your soldier who is my prisoner if you don't do X, Y, then this is taking hostages and is prohibited. Because it's unlawful. This is again Geneva law, and therefore not difficult to establish clear violation if I take a prisoner and I say I will kill this prisoner. You may not kill prisoners.
And parties to a conflict would well know that that is an important element to the peace of prisoners of war, right? That prisoners of war have special protections and actually standards of treatment that they're supposed to receive.
Yeah. And this is why I'm slightly concerned that Israel has stopped the access of the International Committee of the Red Cross to Palestinian prisoners. This is a bad sign, but I hope this will be lifted very soon.
I want to ask one other question related to this concept of physical infrastructure, notably thinking about the evacuation notices that were given to Palestinians in the north of Gaza. From my memory of your course, IHL requires proper notice to be given if a party has determined an area to be affected by a planned attack. There's an element of time to that. There's an element of what proper notice means. So there are two questions here. Does IHL permit this kind of mass notification and movement of people? And what constitutes proper notice?
Perhaps there we must start with the controversial question whether the Gaza Strip is still an occupied territory. If it is, then your question is somehow irrelevant. An occupying power may forcibly displace civilians if this is necessary for their security. But then it must make sure that these people are properly received in another place within the occupied territory, not Egypt. No, that would be unlawful. However, if, as Israel says, and I have a sympathy for this argument, Gaza is no longer, let's say, on the 6th of October was no longer an occupied territory because apparently Israel hasn't control over it. Otherwise, they wouldn't have got all the rockets from there. Then your question becomes relevant, which is that IHL, with some exception, requires a warning before an attack. To warn the civilian population. Obviously, you may not attack the civilians, but you attack a military objective, but you know there are civilians around, and you warn the civilians that they can go away. But the north of the Gaza Strip is not a military objective. There are plenty of military objectives. So a warning can only be for one rocket launcher, one house, one headquarters, whatever. But you cannot say the entire north of the Gaza Strip is a military objective. This is clearly prohibited. And therefore, you cannot make a warning by saying you have to leave the entire north of the Gaza Strip. You can say certain things. We give you a warning, leave these places because we will attack these places. But it is important to stress, and Israel does not technically deny this, that civilians who do not heed the warning, who remain in their houses, remain civilians, and therefore are not legitimate targets. And when you attack legitimate targets, you have to take still into account how many civilians remain, even if you want them.
So thinking more about this question of occupation, and maybe this is something we could have established in the beginning, but is the IHL application of IHL different in Gaza versus the West Bank versus Israel proper?
Yes, absolutely. Israel proper is certainly different than in the occupied territories. The IHL is much more detailed on how you must behave in an occupied territory than how you must behave on your own territory. Now, whether Gaza and the West Bank are different cases or not, this depends on whether you consider that Gaza is still, even after the withdrawal of the Israel Defense Forces in 2005, I think, it remains an occupied territory. And the fact that it is besieged doesn't make it an occupied territory. If you think back to the Second World War, Leningrad was besieged for 2 years by the Germans, but they didn't enter. And it was not, don't tell inhabitants of Leningrad you were occupied by the Germans. No, they are proud that they defend. But the majority opinion is, as Israel had control over the Gaza Strip when it withdrew, and today many competences of an occupying power, like you cannot go into the Gaza Strip without having a permit, and the population register, and the currency, and plenty of things are still run by the Israelis. And this leads the majority opinion and all UN organs to the conclusion that even the Gaza Strip is still an occupied territory. Nevertheless, even they must admit that when it comes to hostilities as we see them now, it is not a law enforcement operation by the police, but it is governed by the law on the conduct of hostility. Because normally, and in the West Bank, this is an important point, in an occupied territory, you cannot conduct hostilities against people, but you have to arrest them and try them. Or you can use force, but just as the Boston police in an extreme situation when life is in immediate danger and so on, while the rules on conduct of hostilities are much more permissive. But I think it is today uncontroversial that in the Gaza Strip there are hostilities, and it's not something which should be dealt with by a law enforcement operation. Nevertheless, when it comes, for instance, to humanitarian aid, the rules are quite different, whether it's an occupied territory or not. If it is an occupied territory, Israel has a responsibility, if necessary, and it is necessary because Gaza doesn't produce enough food, water, electricity, and so on, to give them this. While if it is not an occupied territory, then at least they cannot hinder humanitarian aid to come into the non-occupied territory. And now there are all these negotiations via Rafah. And I mean, if it works via Rafah, from a humanitarian law point of view, that's okay. If it is not an occupied territory. Be careful. If it is an occupied territory, it's Israel which has the responsibility to provide the humanitarian assistance. If it is not an occupied territory, as Israel argues, it must simply not starve the civilian population, and it must accept that humanitarian assistance is brought in, but it may control that this is really humanitarian assistance, and I'm sorry, I didn't make this rule, it may insist upon a control that the beneficiaries are only the civilians, which is an unrealistic rule, because once you distribute in the Gaza Strip, it will also be the Hamas fighters who get food from their wife, from their daughter, from her, and so on. So, but this is not a sufficient reason to stop the water, for instance. Well, you know, petrol is a different thing. Petrol is essential, for instance, for the hospitals. They cannot run. But obviously, it's also important for Hamas. And so, how to make sure that the petrol only benefits to the hospitals and not to Hamas? I mean, when I say Hamas, I mean the Hamas fighters, because Hamas is a movement where there are kindergartens and so on. And so the lady who deals with the kindergarten and is a member of Hamas, obviously, may get water and food and so on.
And so that requirement of either provision of humanitarian assistance or at the very least the allowance of humanitarian assistance to enter is required at all times in conflict and outside of conflict.
Yeah, as I explained, simply the rules are different. As you formulated it, either or, and it depends whether it's an occupied territory or not, but to completely isolate it is anyway a violation of humanitarian. But again, the problem is that Israel can insist that upon a control, not by Israel, but by the humanitarian organizations which do that, provide this assistance, that this doesn't benefit to Hamas. Because you may starve enemy combatants may surrender and then they must be fed. But as long as they don't surrender, they have no right to get humanitarian assistance. The humanitarian assistance must only benefit to the civilian population. And then comes obviously proportionality principle. I mean, if too many civilians starve because you want to make sure that also combatants do not get it, then it becomes disproportionate.
And so what is the responsibility of other actors in the area, Egypt, for example, to, again, either provide that humanitarian assistance or allow that humanitarian assistance into Gaza? Both has a standing, I guess, requirement or obligation, and then also in response to if Israel does not allow this, is there a different requirement or obligation?
Well, I would say Gaza has an obligation to allow, not to provide, because they are not the occupying power. to allow humanitarian assistance from the outside into the Gaza Strip. My understanding is that the main obstacle, at least since the 7th of October, is not Egypt, but Israel. Because if you want to go from Rafah into the Gaza Strip, you have to have, Israel controls a small part of the border, and therefore you have to have the consent by Israel, and Israel has now given the consent for many convoys. But obviously this story of the outer convoys, if I may mention it, raises the difficulty that if there is no ceasefire or now a humanitarian pause or so, then those convoys, they risk to be bombed. And a few days ago, even an ICRC convoy with medical supplies was bombed. I don't think the Israelis deliberately wanted to target it, but simply if there are hostilities, it's very risky with these convoys. And even more, the distribution of the food. We had that in the former Yugoslavia and Sarajevo. People were queuing for bread, and then a rocket came in. And today, a humanitarian organization would consider that it is its responsibility not to make distributions if the people risk to be killed during the distribution.
Mm-hmm. And so is there any sort of obligation to create the conditions for that humanitarian assistance to be delivered and distributed on any of the parties, all parties?
Yeah, and IHL encourages the parties to conclude agreements to make sure that this is, but you cannot say that as soon as a humanitarian assistance convoy is brought, you have to stop, both parties have to stop fire. Obviously, they may not target the convoy, that's clear, but, and there is a need of a minimum of trust, and this doesn't exist between Israel and Hamas. Trust by Israel that this is not abused by the Hamas fighters, and trust by Hamas that this is not abused by Israeli troops to follow the convoy and to enter the regions held by Hamas.
Mm-hmm. So this sort of gets at this concept of humanitarian pauses for temporary pauses. Is this one of the examples of the agreement that should be attempted to be reached in order for?
Yes, indeed. One could also say that somehow, indirectly, it's an obligation because you have to make sure that the civilian population gets supplies. And so it is prohibited to stop all supplies. But if you make it impossible that these supplies are actually delivered, because of the reasons I just explained, one could argue that this is also a violation of humanitarian law. And I repeat, it is absolutely clear, and no one says the opposite, that it is prohibited to attack those humanitarian supplies. But the problem is how to make sure that there are not artillery bombing around it, and that the people who get the supplies are unfortunately incidental victims of attacks against military objectives, which also presupposes that Hamas must promise that they don't take advantage of these convoys to move their own forces.
So another issue related to the Rafah crossing is this question of whether Egypt or if there's an obligation on any party to allow people to leave the Gaza Strip. And related to that, if Egypt has an obligation to allow people to enter, or if there's an obligation on any of the other parties, Hamas, Israel, to allow that.
No, all on the contrary, it is prohibited to forcibly displace protected persons out of an occupied territory. And so Egypt would even be complicit in a kind of ethnic cleansing, or unlawful deportations if it was allowing this. It sounds cynical, but the problem is, in a situation like Gaza, and this has been decided by the International Criminal Tribunal for the former Yugoslavia, if a forcible transfer is not only if you put people into lorries and bring them out, but also if you create conditions where people cannot reasonably anymore stay. And therefore, it would be to say everyone who wants to leave may leave, and then it's not a forcible transfer, is unrealistic, because obviously if you bomb them enough, they all want to leave, while they may stay.
Mm-hmm. Are there other?
But there are exceptions, for instance, for the wounded, seriously wounded and sick, but I understand that this is now more or less done.
Mm-hmm.
And obviously the discrimination, this sounds very discriminatory, that the foreigners are allowed to leave and the Palestinians not. But I mean, the problem is Egypt, like the US, they don't have an obligation to accept anyone to enter.
Mm-hmm. And for individuals able to leave for medical purposes, is there any IHL obligation to then allow them back?
That's a good question. One could say, obviously, if there is an agreement, then the agreement must include that. While if people genuinely, voluntarily leave an occupied territory, I don't see a rule which says, okay, but later you, and this is why you need the agreements, because if there is an agreement, and we have done that in the former Yugoslavia, when people were evacuated, the parties had to sign that those people can come back.
Mm-hmm. Mm-hmm. So some of the parties we've mentioned, the actors we've mentioned, include Israel and Hamas, Egypt a little bit peripherally. What about the rest of the international community? There are obviously many signatories to the Geneva Conventions. What are their obligations under IHL for any of these aspects of the conflict?
Well, there is a common Article 1. In each Geneva Convention, there is an Article 1 which says that the high contracting parties, not only the parties to the conflict, have to respect and ensure respect for the respective convention and of the IHL rules. Now, this has been interpreted by the International Court of Justice, by the Security Council, by most states, but the US disagrees, that this implies that you have an obligation when violations are committed elsewhere to do what you can to stop those violations. But anyway, and this is uncontroversial, you cannot contribute to the violation. So if you give a party weapons, you have a certain obligation to see to it that these weapons are not used in violation of humanitarian law. And I mean, this is true not only for Israel, but say for Iran and Qatar, which supports Hamas. They should use their influence to tell Hamas, don't massacre Israelis.
Mm-hmm.
This is unacceptable, even if you are fighting for a just cause, which is the opinion of Qatar and Iran.
Mm-hmm. And on the other side, the US would also have an obligation to.
Yes. And you know, we cannot be sure that they don't do that.
Mm-hmm.
Because if it is an ally, okay, they make these wonderful statements, but do we know whether Secretary of State Blinken, when he speaks with the Israelis, does say, okay, you have now to make a humanitarian pause. And here you have to let the water again in, and electricity is indispensable for the hospital. And, you know, at least with allies, perhaps it's more efficient to tell them confidentially than to make a big public statement. Also, this is frustrating for us, obviously, because we don't know. I don't know whether he actually does this.
Mm-hmm. And there's no obligation for public.
No, because
Points.
sometimes it's better to do it confidentially. You know, when Secretary Blinken declares that the Russians should not do X, Y in a public statement, does that impress the Russians? I don't know. While if and the US helps very much Israel, if Blinken says, look, you should now nevertheless let electricity and water in and so on, this may, I mean, the progress, I don't know, but it may well be, and it's not only the US, also other Western leaders, when they came to Israel, they first publicly made a big declaration of solidarity, but I still have the illusion that they confidentially also told Israelis, look, you cannot continue as you declared. For instance, with the total closure of the Gaza Strip. Because people, we have to be conscious that the Gaza Strip is not self-sustained. So people, if this had lasted what the Israelis announced, but fortunately did not fully do in the beginning, which is total closure, people would start to die from hunger.
So
and
I'd like
from all kinds of illnesses, because obviously if the water cannot be purified, it's because you don't have electricity and blah, blah, blah.
And so at this point, in terms of the amount of assistance that is going in or not going in, food, water, medicine, fuel, what violations are being committed, if any?
I'm on the facts, I'm not a specialist. So, but my understanding is that for the time being, the amount is not sufficient of what comes in and should be increased, says the UN. But obviously, to increase the food going in, you have to be able to distribute it. And this, again, and this is why now my understanding is perhaps under pressure of other states, Israel just yesterday agreed that there may be local humanitarian pauses, because otherwise you can't distribute your humanitarian assistance, even if it is brought in. But obviously, all this, let us be conscious, is not a solution. I mean, these more than 2 million inhabitants cannot live always from humanitarian assistance. So we need a political solution to the whole situation. But in the meantime, we have to avoid that these poor people die.
I'd like to shift slightly over to thinking about the West Bank, the situation in the West Bank. What are we, so we had a little bit of a discussion about what level of IHL applies there and if it applies differently, because it is an occupied territory. Right. What kinds of obligations and also violations are we seeing?
Well, I think not the most cruel violation, but the most important violations, because it makes peace impossible, are the settlements. Under Article 49.6 of the Fourth Geneva Convention, it is prohibited that the occupying power transfers, even voluntarily, parts of its own population into the occupied territory. And if we hadn't the settlements, it would be easier to find a peaceful settlement of the situation, and the two-state solution would be easier. And today, obviously, there are all kinds of other problems, that there are violent demonstrations in the West Bank in solidarity with Gaza. And I would say Israel has to deal with them under a law enforcement paradigm, which means this is not like Hamas hostilities. This is like a violent demonstration in Boston. The police has to try to stop it, but cannot simply fire on the demonstrators. Except if someone is an immediate threat to human life. I mean, obviously, if someone has a gun and shoots on an Israeli soldier, the Israeli soldier may shoot on the civilians, even in the West Bank. But this is not conduct of hostilities, this is self-defense.
Mhm. We received a question from the audience related to this question about
Yes.
Palestinian civilians who are taken to prison, but including children, but not charged. The concept of administrative detention. Is this considered a kind of hostage system, or what is?
No, it is not. The Fourth Geneva Convention allows to intern protected civilians for imperative security reasons without charging them, but there must be an individual determination, and every 6 months you have to review this determination. So the administrative detention as such is not a violation of humanitarian law. Now, children may be another issue. That here humanitarian law does on this issue not really contain a rule, and in my view, and in the view of the International Court of Justice in the whole opinion, human rights law applies in an occupied territory, and under human rights law, it is not absolutely unlawful to detain children, but it is an extreme measure which has to be avoided whenever possible.
So returning, well, potentially remaining in the West Bank, but more so returning back to the Gaza Strip. The term genocide has been used by some UN experts. It's also been, there have been calls by many. What is your take, your assessment on this term applying to this conflict?
Well, I must say that unfortunately, but again on both sides, there is some discourse which sounds genocidal, like to say these are animals and we have to eradicate them and so on. And on the side of Hamas, I mean, when they speak about the Jews and say Palestine from the Jordan to the Mediterranean, which means we don't want to have Jews here. That would be, as a discourse, somehow the discourse which would accompany then a genocide. But I think the actual acts by the parties cannot yet, as we hope that it will not change, be qualified as genocide.
And so
But the discourse is important. I mean,
yes.
Oh, I just answered from a humanitarian law point of view, but I think, but you know, this discourse is often a minister who is then disavowed by the prime minister and so on. So it is, and even in Hamas, because Hamas now understands, hopefully also under pressure of their friends, that some discourses are counterproductive for their cause, and therefore they start to somehow some of their operatives become more humanitarian, at least in their discourse.
Mm-hmm. And so the elements of even thinking about how do we assess genocide, there's the intention.
Yeah, there must be a special intention to eliminate an ethnic, racial, and so on group. But I mean, both the Palestinians and the Israeli Jews would satisfy this condition. But it is, I mean, and this has been decided by the Yugoslavia Tribunal in Bosnia, where a lot of people have been displaced. To displace people is not yet genocide. It must really be to eliminate them. So to kill them, or another alternative, which is fortunately not relevant in our case, is to avoid births among the group. So really, the aim is to eliminate the group, which was clearly what the Nazis did with the Germans, what the Turks did with the Armenians, what the Houthi did with the Tutsi in Rwanda. But I don't think we are yet, sorry. No, I don't think we are in such a situation. Also, some parts of the discourse is very concerning me, yes.
Mm-hmm. And how does the question of scale factor in?
purely in international criminal law, you can commit a genocide if you have the necessary mens rea, which means the necessary intent to kill all of them, even if you kill only one person. That's theoretically possible, that you commit the crime of genocide, because obviously genocide can be committed by individuals. And therefore, one individual cannot eradicate the whole group. But you can eradicate some people belonging to the group, and this is part of a larger plan to kill all of them.
Mm-hmm. So, looking ahead, what is needed for, first of all, IHL to be upheld for the remainder of this conflict, for however long it goes on, and then afterward, what happens after if IHL has not been upheld?
Well, first of all, I think we should not automatically assume that IHL is never respected, even in this conflict. You know, I'm not in the field, therefore I cannot tell you, but I must tell you, both in the former Yugoslavia or in the war between Iran and Iraq, where I worked in the field, I experienced also plenty of instances of respect of humanitarian law by all parties. Even the Bosnian Serbs respected, in many instances, humanitarian law. I cannot imagine that the Israelis and Hamas never respect humanitarian law, but there's insufficient respect. And third states would put pressure mainly on their allies to say, okay, please, you must do something about it. And obviously, humanitarian law is never the solution. I mean, at a certain moment, the fighting must stop. But Israel must also have guarantees that it will not be again attacked by rockets and so on. And this presupposes, and here I go beyond humanitarian law. Humanitarian law is somehow a provisional solution to bring a minimum of humanity in a profoundly inhumane situation. But then you have to find a political settlement, and this presupposes that both parties make very hard choices of compromise.
Mm-hmm.
And just to give example, well, the two-state solution necessitates that the Palestinians say, we do no longer have a discourse which says the Balfour Declaration and all this, where injustices and all these Jews are a colonial fact here, but that you accept, okay, they are now here, and we must be neighbors. And the Israelis must accept that part of Palestine must be the Palestinian state. And this is why everyone, although it sounds today very unrealistic, is in favor, everyone except Hamas and Netanyahu is in favor of the two states solution.
Mm-hmm. And is there anything in IHL that discusses the possible administration of Gaza after war, or is that a different area?
I mean, they have this is a hard choice now for the Israelis. One possibility is, I would call it, that they reoccupy Gaza, because I think it is not occupied. Now, obviously, there are places now in the hostilities which get under control of the Israel Defense Forces and are therefore occupied. But then, if they want to take control again over Gaza, then they become a full occupying power with all the responsibilities to administer it, to maintain law and order, to provide humanitarian assistance, to make sure that the health system works, and so on. And many say, and I think the US has even advised them, don't do that. Because, I mean, the US has had experience in Iraq, how tough it is to be an occupying power.
Mm-hmm.
But IHL, if they don't occupy, if another solution is found, this is not governed by IHL.
Mm-hmm. So the International Criminal Court opened an investigation into the situation in Palestine. I believe it was in 2021. How might the
Yeah.
current conflict affect this investigation and vice versa?
Well, logically, it should affect, and I trust that the Office of the Prosecutor now looks in all these things. But you know, I explained the conduct of hostilities issues, how difficult it is even to know whether IHL was violated. When it comes to war crimes, you have to find an individual who did it. Either you prove that, say, Prime Minister Netanyahu ordered, and now you attack this hospital, also there's no Hamas there, and so on. And you have to prove that this was knowledge and intent. So it is quite difficult, but this is everywhere difficult. And it is not astonishing that concerning Ukraine, where the prosecutor was very fast, unlike in the case of Palestine, he finally brought out arrest warrants against President Putin for the deportation of children, because it's the easiest case, because you don't even have to check whether these children agreed or didn't agree to be brought to Russia, because it's prohibited even if the children agree, except if the parents also agree, and so on. So this was an easy case. Well, I would say the settlements are also an easy case, because you don't have to make a big inquiry on the ground. While the conduct of hostilities, I repeat myself, is, for a prosecutor, it's not easy to find all the elements. Also, because humanitarian law has some rules like everything which is not a military objective is a civilian object. But the prosecutor has to prove that this was a civilian object. He cannot say, look, dear accused, please prove that this was a military objective. But normally we learn in law that you cannot prove negative facts. So it is difficult in the conduct of hostilities, except if it is accompanied by declarations. So, for instance, those in Hamas who were responsible for the rocket attacks on the 7th of October, there's no difficulty.
Mm-hmm. We received a question from the audience going back a little bit in terms of thinking about the weaponry, and is there any kind of incorporation of a difference in access to weapons and the varying quality of the weapons in assessing how and if something violates international law?
That's a very good question, because indeed, and in 2014, there was also a so-called Operation Protective Edge, where also there were hostilities. And there, at least Hamas tried to make the argument that it wanted to attack military objectives, but unfortunately had such primitive weapons that these weapons could not be sufficiently precisely directed. And here, one has to take into account the possibilities of a party. But I mean, if I have only indiscriminate weapons, I cannot use them. But the precaution, if I have, say, like the US, precision-guided missiles, then I cannot use artillery. While if I don't have them, I can nevertheless, artillery is not as such a non-lethal weapon. Also, in a densely populated area, it always provokes, even if you target really the military objectives, it provokes more victims than if you have precision-guided missile. But this has also a flip side, because obviously all those who criticize the drone attacks and targeted killings, they will say it facilitates you to use force against individuals if you have these precise weapons. But IHL is rather in favor of precise weapons. But you cannot say that if you don't have precise weapons, you can't make war. But you cannot use weapons which cannot be directed against a military objective, but only against the enemy towns. That's unlawful.
Mm-hmm. So there was alleged use of phosphorus gas, for example. Is that
Of what? Sorry?
Of white phosphorus?
Yes.
That would be something that has an indiscriminate element to it. Is that correct? And would
This is controversial. I mean, the US, it's interesting that on the one hand, US military have published articles explaining that white phosphorus is not prohibited. On the other hand, the US has criticized Russia for using white phosphorus. So I rather agree with the US when it criticizes Russia, but then it must also criticize Israel. The problem is that if white phosphorus is used against persons, then it is a violation. While if you use it to illuminate the battlefield, then unfortunately, under the current rules, there is not, like for chemical weapons, a clear prohibition. So you have to apply the general rules.
Mm-hmm. So as we start to get close to the end of our time here, what can we learn from and what do you pull from in learning from previous conflicts, either that you've worked in or recently you were working in Ukraine, either about the application of IHL, the investigative accountability mechanisms that exist? What should we be looking for?
Well, the first thing is we should avoid double standards. Therefore, this is why I mention often what the US said about Russia, then it must also apply to Israel. Because, and this is the second point, that even if you are fighting for a just cause, and I'm sure among those who participate in this webinar, there must be people who consider the Palestinian cause just, and there must be other people who consider the Israeli cause just. But even if you fight for a just cause, you must comply with the rules of international humanitarian law. And the third one, as I said in the beginning, somehow, is don't have illusions about humanitarian law, in the sense that even if it is respected, say, humanitarian law does not prohibit the Israelis to get full control again over the Gaza Strip. And if they want to do that in such a densely populated area, defended by Hamas, there will be inevitably many civilians will die and many civilian buildings will be destroyed. And this is not prohibited by IHL, but if IHL is respected, there will be less. And at least these people get humanitarian assistance and so on. And precautionary measures must be taken and so on. And obviously, beyond that, what we need is peace. And I repeat, peace presupposes that both parties renounce to things which are very dear to them.
Mm-hmm. Well, thank you so much, Professor. Do you have any other concluding remarks that we should take with us?
No, it was a great pleasure to, and I hope that not too many people were disappointed about humanitarian law, because be conscious that skepticism about humanitarian law and the impression that it is anyway never respected undermines the willingness of those who have to respect humanitarian law. If you think as a soldier or as a fighter that you are the only idiot who respects the rules, you will no longer respect them.
Mm-hmm. Mm-hmm. Well, thank you so much. Thank you to everyone who joined us. I'm getting lots of notes of appreciation here in the chat, and I send you my deepest appreciation for joining us today. I know you're
Thank
quite.
you.
Thank
It's been a
you.
pleasure.
Thanks.
Goodbye.
Goodbye,
Bye.
everyone.